Lock that door.
Goodbye, Mom.
Hey guys. So you get a little treat today. I'm taking my son to the park with me. How's it going, guys? All right, so this is still buffering. Give me some 5x5s that you guys can hear me. Just want to make sure you didn't miss anything. So give me some 5x5 so I know you guys can hear me. Want to make sure, Simba B, that you can hear me and that I'm live. Because yeah, I do have sometimes I have problems with being cut off. Okay, good to go. All right. So I am attorney Michael Ehline. I'm an attorney licensed in California and Texas. Unfortunately, we were buffering, so I'll do the intro over a little again. Today is a special day. I'm headed over to the park to do some PT with my son, who's a judoka. And I'm going to go ahead and talk about, I'm going to go ahead and talk about
Give me that title.
U.S. versus Peterson. Okay, I'm live, okay? It's calmate. All right. So U.S. versus Peterson, and I had the honor of attending court at the Fifth Circuit years ago with Dick Heller of District of Columbia versus Heller, the seminal case on Second Amendment rights, with my friend attorney Alan Beck. He's also an inactive U.S. Marine. He was a tanker. And Alan and I have been friends for years, and he works with the Ehline law firm. And I primarily don't do civil rights and Second Amendment rights cases as my practice, because there's really no way that I can support a family doing that. So I do personal injury law, and I have one of the largest settlements in the history of the United States for a motorcycle accident case involving an Army veteran, former airborne Army soldier. And so what I do is I use I use my earnings, anything over that I don't have to use for my family, to engage in advocacy. So like the civil rights law, and primarily Second Amendment, and then First Amendment. So I'm pretty popular in the First Amendment auditor community. I'm a real big believer in holding government officials accountable. And Simba B, just make sure that you chat every once in a while so I can make sure I'm not buffering, okay? Because sometimes I know it just disappears on me, and I'll just be talking and you guys will say, I didn't hear anything for the last 10 minutes. So I'm coming at you live from Summerlin, Nevada, and I'm gonna talk about U.S. versus Peterson and the suppressor case. All right, and this is an important case.
Doberman.
What's that?
That's a Doberman, ain't it?
Oh, you saw a Doberman?
No, the dog breed.
Oh, over there. Oh, cool. All right, outstanding, William. All right, so I am a legal authority on Second Amendment rights law, and I am good friends with Dick Heller, and he's one of my heroes. I consider him to be a national hero. So if you guys don't know who Dick Heller is, take a look at District of Columbia versus Heller. If you want to learn a little bit more about your God-granted, unalienable rights of self-defense. I think that Justice Scalia did a great job in that case, and I think it's definitely worth reading and sharing with your children. And so, give me a bunch of ones for my son getting up at dark 30 to go and work out at the park today while I discuss your Second Amendment rights with you, because this is pretty important. All right, speed it up, Gunny. Try to get closer to me. I don't want to have to take out this freaking four-legged beast over here if he gets crazy. All right, let's take a look here. Hey, what's going on, Allie Bell? So we're going to talk a little bit about U.S. versus Peterson, and I have prepared a bunch of notes and stuff that I brought with me while my son's working out, so we can talk a little bit more about this. But so this is coming on the heels, just to paraphrase a little bit about U.S. versus Peterson and why it's important to you and I, is because number one, if any of you guys are shooters and you're involved in a life-threatening situation, it's really difficult to get your hearing protection, to get what we call your ears in the Marine Corps, right? Or the other branches probably too. So when you're putting rounds downrange, what's going to happen is you're going to blow your eardrums out. And that's why I have major hearing loss from when I was back in '89. Because even though they gave us little foam ear protectors, you couldn't hear commands with those things in. So it was sort of an unspoken rule that you don't wear hearing protection when you're out at the range or out in the field doing firearms training. At least when you're doing like live fire exercises. All right, so because of that, our military recognized during the GWAT that suppressors were really important. And all a suppressor is, it's a baffler that goes on the end of your weapon, typically a rifle, but they can be used for pistols as well. And it protects your ears. And so the Hearing Protection Act was before the United States Congress just a couple of weeks ago, and a couple of turncoat anti-American rhino Republicans joined with the Marxist Democrats to defeat that bill. And so because of that, under the National Firearms Act, the NFA, they're still illegal. And so the argument is, and this is basically California's argument is that every accessory of a firearm, including a trigger, a magazine, in and of itself is not a firearm, and therefore they can be individually banned. And that's what the Marxist Democrats are trying to do right now, is they're trying to outlaw your ability to have a firearm by making all the accessories illegal. And a couple of Joe Biden Marxist Democrat holdovers had this case at the Fifth Circuit, and they basically hamstrung our ability with their briefs before the original court, before the original circuit court judge, saying just that. And it went up to the Fifth Circuit, and what ended up happening is the Fifth Circuit agreed with these Obama attorneys, Obama, Biden, whatever, same thing, globalists, anti-Americans, that suppressors are not an integral part of a gun. They're just an accessory. You can't use them as a weapon unless they're connected to the gun. Well, just like a magazine, right? Just like a trigger. So you can see where the argument's headed, right? And I just did a video yesterday about how Communist Fornia is trying to outlaw Glocks, saying that they're readily convertible to a fully automatic firearm. And I did make a mistake that I want to correct. I said that all firearms are easily and readily convertible to a fully automatic firearm. So I have to strike that. All semi-automatic firearms are readily capable of being converted to full auto. It just has to do with the sear pin. So if you can cut off the sear pin, like you can put in what's called the Glock switch, you can make your rifle or pistol fire full auto. So because we got some conservative justices, luckily, many of them appointed by Mr. Trump, we were able to sort of reclaim our Second Amendment rights from the left. But the left, of course, you know, their ultimate goal is to make us like Australia or the United Kingdom and not be able to have firearms at all. Easier to control someone if they're not able to defend themselves. So what ended up happening is there were some holdover leftist attorneys from Biden, and of course the government holds great sway with the Court of Appeal and other courts. And so the DOJ argued, the Biden holdovers argued that no, a suppressor is not an integral part of a firearm. It's not a firearm. It's just an accessory, and therefore it can be banned, and upheld the NFA on suppressors. And again, this comes on the heels of the Firearms Protection Act that should have passed, but for some turncoat Republicans, that now would allow you to protect your hearing. So before I get more into the case and pull out my notes, what I want to do is explain to you what a suppressor does. A suppressor baffles sound, but with a 7.62 or a 5.56 NATO ball, you can still hear it, okay? It's not like those old Chips movies or TV shows or A-Team where you hear like a little chirp, chirp, chirp. It's not what it sounds like. You can hear them. I can hear them at 300 yards. What it does, though, is it reduces the decibel sound of the firearm to a point where you don't have to wear hearing protection. So it protects the shooter. And therefore, it's an integral part of the firearm because it makes the firearm more safe and more effective, because now you could hear commands like maybe law enforcement saying, drop it. Okay, so it actually works to protect the public and the safety of individuals. All right, Gunner, so what I'm gonna have you do is just do your stretching exercises that you did yesterday. And while you're doing that, I'm gonna go ahead and talk to my audience here. All right. Yeah, and make sure to hit that like and subscribe button. Hit that like and subscribe button. All right. Just let me know when you need help, when you need me to help you do pull-ups, okay, buddy? Gunner? All right. Well, give me a bunch of ones for Gunner getting up early and learning discipline, because that's what it's all about. That's what a father's job is. It's 0524, and he's up with his dad learning how to get in shape and being disciplined. So check him out. What a legit little dude. All right, so here's what ended up happening. The suppressor challenge that was ruled on by the Fifth Circuit Court of Appeals, that was before a 3-judge panel, was withdrawn by the same guys that originally ruled against Mr. Peterson. And so again, I talked about the fact that this has to do with the NFA and the constitutionality of suppressors being outlawed. So Mr. Peterson originally was charged with violating the NFA, and he was convicted. And he was basically convicted because, well, we'll get into that in a minute, but ultimately what he argued is that suppressor restrictions violate the Second Amendment, and on review, the Fifth Circuit judge panel ruled, like I told you, that suppressors aren't arms. It's very dangerous, because now they can say that, well, guess what else aren't arms? Triggers. Triggers aren't arms either. So if triggers aren't arms, that means that they can outlaw triggers, which is what they're trying to do, by the way. Or they can just outlaw, a front sight tip. They can outlaw trigicons. They can outlaw anything they want, okay? Anything that's an accessory of the firearm, they can outlaw, which goes against the Second Amendment, obviously. So I'm doing it, William. I'm teaching them those Marine Corps values and judo and stuff like that, keep them squared away. So because the DOJ holdovers, the Obama-Biden holdover attorneys for the Department of Justice said that no, we don't, suppressors aren't arms, and therefore we can ban them. So the 3-judge panel agreed with the government. But then once Trump got a hold of it with Pam Bondi, that changed. And so they reversed position, and then the 3-judge panel vacated their findings and sent it back. So typically what would happen when that goes down is, when something like that goes down is the Court of Appeals will hear that en banc, and that's what they do at the Ninth Circuit. All those left-wing Marxist justices, say many, will do what's en banc. We'll have a full panel, and then they'll rule on it, and they'll decide whether or not it's legal or not. And then it gets held up for years, and you know, it could be until they get another Democrat in power, and that's what their goal is, and that's what they're doing. That's what they're doing all the time now with the border, trying to make sure the illegals don't get deported, because they need them in order to redistrict all of the blue states further Democrat. So the reason why Biden flooded the border with illegals is so he could redistrict using the U.S. Census. And then what they do is they send them to Democrat sanctuary states. They don't even need to vote. What they do is they redistrict. So that's the game. And so these district court judges can hold up these cases for years at a time, and they're Democrat judges, of course. And that's the way it works. So this is a similar method that they use to try and abrogate your Second Amendment rights. Hopefully you understand that, William. Give me a bunch of ones if you guys are understanding so far. So the DOJ, through Pam Bundy, replied in their new brief that suppressors are arms and they cannot be banned outright by either a state or federal government. And they also are arguing that the NFA's restrictions do not amount, well, hold on, strike that. They argue that an outright ban is inconsistent with the Second Amendment. And they also said to the Fifth Circuit that the Fifth Circuit should potentially take the case or re-review the case, hold on, and reverse it because suppressors are protected arms. That's what the DOJ is now saying. So what a difference an administration makes. Even though I don't agree with Trump on everything, I'm a libertarian, so I don't really respect either party. But in this case, this is one of those things that the Trump administration is doing that's right. Thank you, Woodery Stay Love, Heike Woodery Stay Love. Much respect to you too. So under Bondi, we got lucky, and she is arguing that no, suppressors are absolutely protected. So even though the Republicans and Democrats defeated the Hearing Protection Act, we've got a second chance now to have legal suppressors, so we don't have to worry about wearing hearing protection. So, right, we'll talk about that in a minute, Heike. So, a 3-judge panel that issued the original ruling pulled their opinion, which is well, it's not unprecedented, but it's extremely rare. You okay, buddy?
Didn't mean to do that.
You all right?
Yeah.
All right. So I'm out here with my son today doing a little bit of training, trying to get him strong for judo. So ultimately, give my son a bunch of ones, guys, for showing up with his dad at Dark 30. How many boys do you know that will get up at 5 a.m. to go train with their dad at the park? That is unprecedented. Give me a bunch of ones if you agree. So let's see here if I can flip this bad chicken around so you can kind of get it. Well, that's a 16-year-old boy who's on his way to becoming an Olympic judo champion.
Quiet.
All right. All right. All right. So basically, they pulled that opinion, and so the 3-judge panel that issued that decision typically would send it for en banc for the full panel to hear, or rehear the case. But so what it looks like they did is they sent it back to the original judge, probably a Democrat judge, to make a new ruling based upon the Department of Justice's new argument, the Republican Department of Justice's new argument that in fact suppressors are arms and they're an integral part of a firearm. And I can tell you right now, they are. Suppressors protect your hearing and make the firearm more effective. So here's what happened. Back in 2022, federal and state law enforcement officers, you know what they like to do if you're not part of their left-wing commie cabal, right? They sent a bunch of state and federal law enforcement officers to execute a warrant at Mr. Peterson's home where he lives in Louisiana. And he also is an FFL, a federally firearm licensed dealer. And so I used to make fun of these guys because I do 2A. We have a name for ATF, always think forfeiture. All they want to do is take your federal firearms permit away because it's just full of radical leftists that are in the ATF. And they hate firearms and they want to disarm you because they think that only the government should be able to have guns. In a nutshell, that's the reality, guys. So there was basically, now I'm not totally sure, I can't remember specifically, but he had like a part of his house was like a firearms dealer. So that's Louisiana for you. Give me a bunch of ones for Louisiana. So they issued that warrant, and the warrant was based on some issues with him operating a gun store on the property, and that there were allegedly some straw man purchases, some improper record keeping. That's how they always try to take your permit away. Just like the IRS, they'll always find something. Show me the man and I'll show you the crime. Joe Stalin administration, right? So they they're basically said there were a bunch of problems with firearms that were purchased at his gun store that was connected to his house. And there allegedly some of these firearms showed up at crime scenes, and Basically, he had a solvent trap that was not registered, and that's how they were able, I guess, to get the warrant. And that got Mr. Peterson where that's what led to the lawsuit for Mr. Peterson. And so the unregistered solvent trap was what started all this. And Mr. Peterson brought a case where he challenged his conviction, a criminal conviction, and then he filed a motion to dismiss the charge based on the Second Amendment. And then that went up on review. The original lower court denied the motion to dismiss the indictment, and that led to Mr. Peterson to appeal to the Fifth Circuit for a reversal. And a 3-judge panel, because of these Obama/Biden attorneys that work for the DOJ, went ahead and said, no, we're going to side with the ATF and the Biden administration, that at the time of the ruling, we believe that that suppressors are not arms, okay? That suppressors are not arms. And this was an issue of first impression for the Fifth Circuit, and as far as they could tell, every other court had decided that suppressors are not arms, okay? It's not a weapon of offense or defense. It can't be used to cast at or strike another person, and therefore the 3-judge panel incorrectly found that they're not protected arms, that suppressors aren't protected arms. What's up, Cannon? And Peterson said that the suppressors are an integral part of the firearm, which I've argued for years, and they do warrant Second Amendment protection, and that a suppressor by itself is a weapon, being attached or not. Just like a trigger is a weapon, whether it's attached to your firearm or not, because it's almost like saying, well, a heart's not a human. The heart's not part of the human body, and therefore hearts should be banned. Well, you wouldn't be able to function as a human, okay? Just common sense. All right. So give me a bunch of ones if you guys understand so far. By the way, guys, I do appreciate all the membership purchases that you guys have been getting, because it goes out to other people who need to learn about their God-granted unalienable rights that were not granted by the Constitution or the Bill of Rights. They were granted by God and recognized in our Founding Father documents. All right. So the 3-judge panel said that suppressors are not necessary parts of the firearm, and they are not required to make a firearm useful or actually function. And I discussed earlier why they are required to make it function better, because they protect your ears, and you can also hear field commands, and you could even hear a law enforcement officer telling you to drop the weapon. If your ears are blown out from firing a firearm, you're not going to hear anything. You're going to hear ringing in your ears, and you're ultimately going to get tinnitus like what I have. I have such a hard time hearing now from small arms that my wife is always telling me, why do you talk so loud? And I'm like, what do you mean? What do you mean? So we're almost done, Gunny. You want to do some pull-ups really quick? Okay, I'm going to help you. Just let me set up the cam. Let me set up the cam over there so I can keep talking to people. All right, so I'm over here training my son, so just forgive me for the interruption in this. But for all you fathers out there who think that your sons are a lost cause, you can see me and my son, and it's all about the father. It's 1,000,000% about the father that makes the son. All right, let's try to do 10. Warmed up enough? All right. Good push. 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Outstanding. All right. So, Gunner, let's go sit at the benches. Let me finish. Can you grab my gear for me? Just throw all that paperwork in the freaking backpack, and just throw your stuff in the backpack too. We're gonna go sit at a bench. It'll take me about 15 minutes to close this out, and then we'll go home. Okay?
Why not?
Copy that. All right. Just bear with me, guys. And yes, well, Marty Lewis, are you a female? Because it's usually the women who don't understand why suppressors are important, because you don't know anything about firearms. So I presume that that's what's going on. Democrats love women because they're more emotion-based voters, and they don't understand the significance of suppressors. But if you watch the beginning of the video, you'll see how important they are with respect to protecting your hearing. And you can also, hey, James Forbes, what's up, Devil Dog? And you can also go on the internet or Grok or something, and you can look up the Hearing Protection Act that was defeated by some turncoat Republicans just recently that would have made it legal to have a suppressor without having to worry about it. Basically what happened is high estrogen voters years ago decided that they saw chips in the A-team, and they saw how suppressors, they call them silencers, could silence a weapon, and therefore you couldn't hear it and wouldn't know where the round was coming from, which is nonsense. You definitely can hear a suppressor. What it does is it reduces the decibels so you don't blow your eardrums out. And we discussed why hearing protection is not always possible, like if you wake up in the middle of the night to a home invader, like one of the illegal alien invader criminals from Venezuela that broke into your house, that you'd have a problem. So what a lot of people believed is that this was going to go to a hearing en banc with the Fifth Circuit, which is a full panel like they do at the Ninth Circuit. But the cool thing about the Fifth Circuit, guys, and this is why we always try to get our gun cases in the Fifth Circuit, is because it's a more conservative circuit and more pro-Constitution, more pro-Bill of Rights, unlike the Marxist-leaning Ninth Circuit, all right? So, yeah, but you're right, Terry, absolutely. So, originally, the Biden administration, DOJ, and its holdover attorneys argued that they're not arms, and we discussed that. But again, after the Trump administration got their hands on this case, they changed their position. The Fifth Circuit 3-judge panel, they vacated their original opinion and sent it back to the trial court to have a hearing based upon the new arguments of the more pro-Second Amendment Trump DOJ, all right? And a magazine is not a clip, that is correct, unless it's an M1, right? An M1 Garand, I believe it's a Garand, is a freaking doggone clip. Is it the Garand? Yeah, I think it's the Garand. So let's get into, just give me a minute, Gunny. All right. So the United States argued that the Second Amendment protects firearms accessories and components such as suppressors, and as a result, restrictions on possession of suppressors do in fact burden the right to keep and bear arms, and a ban on the possession of a suppressor or similar accessory is unconstitutional. And the government's earlier argument to the contrary was incorrect. And you can still get a suppressor, but you have to pay for a special license, okay, and a tax stamp license. It's just ridiculous. But in California, you can't get them at all because Communist California doesn't want you to have any kind of firearm. What's up, Lynn? So because of that, what they were saying is that the registration and taxation requirement is not constitutional, even though the Biden attorney said that, oh, it's just a modest burden on a firearms accessory. It's like $250 or $400 to get this tax stamp. It's expensive. Like you can't get a short-barreled rifle or anything like that. So, and it's not consistent with the historic tradition. But the Biden the Biden attorneys argue that they're especially adaptable to criminal misuse, and for this reason, the Biden attorney said, "Oh no, because of that, the Peterson's conviction should be affirmed, and that a rehearing en banc isn't necessary, etc., etc." So ultimately, I believe, and the DOJ believe, that the Fifth Circuit 3-judge panel got the analysis wrong, where they talked about suppressors not being protected arms, and as a result, they, rather than rehear it, they did rehear it, but not on a full panel. And I'm trying to paraphrase because I got my son with me, so I want to get back home. The Fifth Circuit has now pulled their prior order on the suppressor, and it is no longer valid. It's no longer valid, and the court's directive and opinion was withdrawn, and let's go. It's probably not going to go en banc. It's going to go back to the original judge. The panel probably isn't going to reconsider it, with respect to upholding the conviction. They're going to send it back to the original judge to make an opinion consistent with the Department of Justice's arguments that, in fact, suppressors are an integral part of the firearm. So if they have a Democrat judge, obviously he's going to vote against it because Democrats don't want us to be able to defend ourselves, right, against the invaders that they flooded into our country, 20 million of them by some estimates. So what's going to end up happening is the new brief is going to be reviewed by the lower court judge, and basically they're going to argue that it needs to be reconsidered. So the Fifth Circuit probably is not going to reconsider the case in light of the new position and new arguments made by the Trump administration, since both Mr. Peterson and the DOJ are saying that the only reason they should take review is to reverse it. But what they did is they just vacated their opinion. So rather than reverse the conviction, they vacated their opinion that suppressors are not arms. And it's probably going to have a re-review of the NFA taxation registration process because they pulled that decision. So it could end up being reviewed again by the 3-judge panel, or probably more likely it's going to go back to the original judge. I'm not totally sure. I've got to do some more research. It's getting hot out here, so I want to crank this out as quickly as I can. So the Trump DOJ is arguing that the NFA's process is not constitutional, and we're gonna have to look at the briefs. But ultimately, what the Trump administration is arguing is that suppressors are protected arms under the Second Amendment, and that alone would be a huge win for all of us, people who support the Constitution, because it would create a critical split. And I talked about jurisdictional splits the other day and why case law is important in our American common law system. Because once there's a jurisdictional split between, like, say, California and another circuit, it goes to the Supreme Court in order for them to ultimately arbite it. And we need to do this now, because if we get a couple more Ketanji Browns who can't even define the difference between a man and a woman, we already know how she's going to rule. She's going to rule in favor of the Marxist Democrats. So we need to get it up there now, and so that's why this is an important decision. So the 10th Circuit and the 9th Circuit and others believe that suppressors are not protected arms, just like they believe magazines aren't protected arms and triggers aren't protected arms, front sight tips aren't protected arms, they're all just accessories. So with that argument, they can ban all firearms by just banning a component of the firearm that makes it effective and makes it workable, usable, and safe. And in this case, I believe, and I think most of my audience believes, that suppressors make a firearm safe. And you can call me Mike, brother. That's all good, James. Everybody called me Mike. My wife is the one who wants me to use Michael. She thinks it sounds more professional as a lawyer.
That's true.
Right, and my son agrees. So what'd you say, buddy? Tell us what you said.
I said that's true.
All right, outstanding. All right, so he agrees with his mom. Another reason why I love him, because he supports my decision to make sure he had a good mom. All right, now, this is in the Fifth Circuit now, and as I get additional information, I'm going to let you know what's going on with the case. So let me just really quickly, before I go, just explain to you. So in 1934, the National Firearms Act was passed. It's a federal law regulating the sale and possession and transfer of firearms and devices like machine guns, short-barreled rifles, suppressors, and things of that nature. And it's being handled by the Bureau of Alcohol, Tobacco, and Firearms, all right? And it's just pretty wild to me, but... And then really quickly, I'm going to get into, hey, Lynn Davidson, a firearm suppressor, commonly known as a silencer, I just want you to know what it is attached to the barrel of a firearm to reduce the noise and muzzle flash so you can use the firearm more effectively. So in effect, it makes the firearm more effective and protects the user of the firearm's hearing, so you don't have hearing loss like I have from small arms fire. So like if you're fighting in a unit and you're attacked and you don't have time to put your ears on, what we call ear protection, you're not going to go deaf and then make a bunch of hearing loss claims with the VA once you get out. Oh, and Lynn Davidson says, hi, Gunner. So one of my viewers says hi. Say hi back.
Hello, Lynn. How have you been?
He says, how you been, Lynn? So give me a bunch of ones for Gunner joining me today, being a champ. All right, so it works by trapping and dissipating expanding gases from the gunshot through a series of baffles or chambers, lowering the sound level to safe decibels. That's all it does. You still can hear it, guys. It's not like the old Chips or any of those other movies. Man, look at my eyebrows. Very Swedish. Man alive, I look like a Navy Sea Admiral, for crying out loud. So in the U.S., suppressors are regulated under the National Firearms Act of 1934, like I said, and it requires a tax stamp, a federal tax stamp of $200 to get one, but you can't get them at all in Communist California, all right? And you can't even have a threaded barrel on your firearm. If you have a threaded barrel attached to your firearm, I believe that's a felony in California. But it's Gunnar, G-U-N-N-A-R-R. It means battle warrior in ancient Norse. I'm a Swede, so we named our son after his grandfather, who was also a Swede. So the HPA argues that suppressors are critical for protecting shooters' hearing, and because firearms can produce sound exceeding 140 decibels, and that can cause permanent hearing loss without protection, which I have permanent hearing loss, and part of my 70% disability with the VA is because of my hearing loss. So there you go. And let's just get into a little bit more. And of course, if you get a tax stamp, you're subject to being searched and seized and regular background checks. It's a nightmare. It's crazy to exercise your fundamental, unalienable right to keep and bear arms. You've got to get a special license, right? Just it reminds me of Mao Zedong under communist China. So proponents like myself and the Gun Owners Association of America and the NRA emphasize hearing safety and note that suppressors are legal with fewer restrictions in many countries, like even in the UK and New Zealand. Even though you can't get your hands on a firearm there, at least suppressors are legal, right? Or have less restrictions. So, and even some gun control advocates argue that easier access could, well, they're saying that easier access could complicate law enforcement efforts or increase risks in criminal scenarios through evidence leaking suppressors to crime, whatever. If you want specifics on the HPA status or suppressor regulations in particular, let me know and I'll do another show about it. So Gunny, can you stow this gear away in my backpack? And then we'll get on the road. You guys have any questions for me before I get on the road? And stow this in there too. Well, Jen Mitchell, the issue is in California, they're trying to ban every single part of the firearm and declare it to be an accessory. And why are they doing that? Well, because they can ban firearms backdoor it. They can backdoor it that way. And that's what the left always tries to do. They try to find these novel arguments to find a way to strip you and I of our fundamental, unalienable rights to keep and bear arms. So I did not do a workout this morning because I'm really sore from the other day. But I do appreciate you guys joining me. Are you upset at me I didn't do a workout?
Sort of.
All right, so you want me to do some push-ups at least? I mean, I can do some. All right. So Gunner's upset at me. He thinks that I'm that I'm pussing out because I didn't do push-ups.
Oh, it's not that deep, man.
See you later, James. So let's head on back. Do you want to take the long walk around, or do you want to take that one and just go home?
Why would we take a long walk?
Well, the long walk gives us more exercise.
Yeah, sure.
All right, so we're going to take the long walk. So we're going to take the long walk. Take the long way home. 3 Dog Night, baby. Take the long way home. All right. So again, I am attorney Michael Ehline. I'm a Second Amendment rights attorney, but my primary practice is catastrophic injuries. And I use the money that I make from my catastrophic injury cases to help me fund my hobby, which is protecting people's Second Amendment rights. So if you do have a Second Amendment rights case, that's really not what I do. I don't do it to make money. I do it because I want to protect people's rights under the Bill of Rights and the Constitution that are basically God-granted rights, and that's what I do. So I try to help people. I am an authority on the Second Amendment, and I hope that you enjoyed a little bit of our discussion today about firearm suppressors and the U.S. versus Peterson case that's presently before the Fifth Circuit in Louisiana. Now, it's not 3 Dog Night? Well, which one is it, Joe? So Joe Liberalism says that take the long way home. Oh, Supertramp, that's right. Sorry, guys. Well, hey, at least I got corrected. So one thing you'll also notice about me is that I don't try and argue that I'm right if I can be proven wrong, because I am an evidenced and rule-based man. So I believe in people being able to argue their case, and if they have evidence and they can prove me wrong, then I'll accept it. I won't be like most of these internet trolls who keep trying to argue something that's not true. So that's another cool thing about being part of Team MPE, is that we present our case and then we let the jury decide. And in this case, you won, buddy. So 36 years, that's right. Okay, that's cool, Lynn Davidson. So does anybody have any other questions? Because I'm probably just gonna, because I'm holding a gimbal and it's kind of uncomfortable. I'm with my son going for a walk, and I definitely want to be able to counsel him and talk to him about vision quests and things like that that dads need to talk about. So really quickly, let me just see if there's any questions. And if not, Lynn Davidson, to get my phone number, reach out to BZ Watchdog. Let him know that we spoke and you're good to go if you need to talk to me. But text me, don't call me, because I'm going to be in depositions most of the day today. So I'm not going to have a whole lot of time to be able to talk to anybody. Morning, ladies. Morning, sir. That's what I like to see. Take away all that business from Big Pharma by squaring away your bodies, guys. Go on a high-protein diet. I'm doing the carnivore right now. Protein powder, square yourselves away, work out. Don't inject your body with stuff just because someone tells you that it's safe and effective. Do your own research, just like I do as a lawyer. Don't ever take the government's word. Never trust the government. All right. So, and we'll talk about it later, Lynn Davidson. No, the Second Amendment is not a God-granted right. The right to keep and bear arms and defend your family is a God-granted right. Mr. David Lavigne, and of course I earned it. Yeah, I was in the Marine Corps. I'm a 70% disabled Marine. I can barely walk. I'm in so much pain right now, but I'm doing it because I'm trying to teach my son discipline and bearing and how to be a real man. So someday he'll be able to find the right woman that he's equally yoked with and be able to provide the protection and support that she needs. And that's what a father's job is, ultimately. So the Second Amendment is a recognition of a pre-existing God-granted right. That's all it is, just a recognition, because many of our founding fathers felt that they needed to include